Good afternoon. Welcome to Venable's webinar, How Will the CFPB's Proposed Arbitration Clause Ban Impact You? My name is Allison Baker. I'm a partner here at Venable, and I work predominantly on consumer finance-related issues, litigation, enforcement, and regulatory concerns. And I'm joined by a really fantastic group of panelists today to discuss in detail how the CFPB's proposed arbitration rule will impact you and others. First up, we'll be speaking Peter Frechette, who is an associate in the Consumer Finance Practice Group here at Venable. Peter has worked extensively on the arbitration-related rulemaking issues. He has read in detail and helped comment on the proposed arbitration rule, and will be speaking a great deal about what the CFPB's proposal is and also the provision of the Dodd-Frank Act that informs the reporting requirement that the CFPB has put out there. In addition, Tom Gilbertson will be speaking, and Tom is a partner in our litigation group. Tom specializes in class action defense work and has spent the last 20-odd years thinking about, talking about, and writing about arbitration clauses and class action related issues, and he will be giving us his perspective today. And finally, we will be joined by John Cooney. John is a partner in our regulatory practice here at Venable. John specializes in appellate issues, constitutional legal issues, and administrative legal issues. And John will be speaking about whether and how the CFPB's proposed arbitration rule might be susceptible to some kind of court challenge. And with that, I will turn it over to Peter, who will start out by explaining to us what the CFPB's proposed rulemaking looks like and what kind of provisions in the Dodd-Frank Act the CFPB is responding to in issuing its reports. Thank you, and good afternoon, Peter.
Thanks, Allison. So just to quickly go over Section 1028, which is obviously the section in Dodd-Frank that gives the Bureau the mandate to conduct a study of these arbitration clauses and then provides authority to conduct this rulemaking and, again, to prohibit or impose conditions or limitations on arbitration clauses or agreements. So, going through the three sections of 1028, you have the study and report, which we've seen last spring, almost a year ago now. What we're dealing with now is the further authority, where the Bureau can propose a rule. And we've seen what we've seen so far is a proposed framework, and we're waiting on the notice of proposed rulemaking. But then there are conditions within 1028 that are going to be important as we expect the NPRM and so move into the comment process on that. So just looking at, obviously, they could the Bureau could ban arbitration clauses completely, or as what we've seen sort of proposed so far is impose conditions or limitations. But again, these are tied back to the Bureau's study. First, in the sense that they have to be consistent with the study, but then also they have to be in the public interest and for the protection of consumers. So there are a few nuances within the statute itself that provides the authority that are probably going to come into play as we look at the proposed rule. And then again, the statutory authority provides limitations on when any proposed rule can become effective in Section C. So that will come into play as well. Just to tee it up for the further discussion, it doesn't provide the Bureau any authority, but the Federal Arbitration Act is likely going to be brought up in the context of the rulemaking proceeding and discussion surrounding it. So I wanted to tee the language of Section 2 of that Act up for our viewers, just because it's going to be coming up along with the Concepcion line of cases as we dig into this. And
Peter, I just wanted to clarify for folks who are listening to our webinar today that the Concepcion line of cases, of course, are the Supreme Court case Concepcion, which was in 2012, and then Italian Colors, and then most recently DirecTV, are three recent Supreme Court cases that concern the issues of arbitration clauses and specifically class action in the context of arbitration. And the Federal Arbitration Act, of course, is front and center in those lines of cases. So that definitely informs the CFPB's actions here and also informs the mandate that the CFPB has under Section 1028, as you're describing, Peter.
Exactly. That's exactly right. So moving on to the proposal itself, and just to reiterate, what we've seen so far is a proposed framework, a loose guideline of what the proposed rule might actually look like. So we haven't seen actual proposed rule language. We have a sense based on what the Bureau has issued for its SBREFA process and has sort of been workshopping with different trade associations and small business groups, gives us a sense of what the actual proposed rule might look like. But again, we haven't seen that language yet. What we have seen indicates sort of two ways that the Bureau is approaching this. First is not, and although the Bureau could do it, not an overall ban generally of arbitration agreements, but rather a ban of the so-called class action waiver. You see that in the first proposal that the Bureau has put forward, which specifically would be language, and they've indicated they will likely provide model language, that agreements will have to explicitly state that the arbitration agreement is not applicable to cases that are filed in court on behalf of the class unless the class certification is denied or the class claims are dismissed. So that is what many have taken to be the sort of ban of the class action waiver, and that's the ban contained in the proposal we see, which again is it's not the overall ban, but is likely to be extremely important for industry. The second part, which might have been getting a little bit less press, but again is requiring a regulatory requirement where industry would have to post arbitral claims and awards. And what we're seeing with this is it's looking at the individual arbitration clauses, clauses dealing with individual arbitration, and not rules or regulations of these clauses yet, but maybe looking towards further regulation of these clauses, sort of determining what types of arbitration clauses are good for consumers and what may not be, and so starting to collect additional information that the Bureau can use for further rulemaking proceedings. Moving on from the actual proposals, just a brief recap of the affected parties, which are obviously casts a wide net and involves most of the covered entities under the Consumer Financial Protection Act. And really, if you see the last bullet there, might move beyond even companies and industries where we have traditionally seen arbitration agreements focused on consumers, and the Bureau has specifically highlighted payment processing as one of those industries where a consumer-focused arbitration agreement clause might not traditionally be what you think of when you think of a payment processor, but nonetheless they're called out in the proposal as an area that the Bureau is looking at. And again, they include some exceptions, so we'll see as we eventually see the NPRM how exactly the Bureau is going to cut its scope of its rule.
One of the interesting things that has been percolating for a long time with the CFPB is what is a consumer financial product or service. I mean, there's clearly a list here that I think is indisputably, a list of products and services that fall within that definition, but I can think of a lot of others that may not, and yet the Bureau may have a different view of that. And this particular issue, combined with the pending arbitration rulemaking, will really take this to a new level, because if you're within or without the scope of the CFPB, you're going to need to know when you write and rewrite your consumer finance contracts. And so, I think from a risk management perspective, this is obviously something everybody's watching very closely too when the notice of proposed rulemaking comes out. Peter, I don't know if you've had any sense of that from your dealings with people as you talk about this arbitration rulemaking.
And not really. I mean, again, the Bureau is really casting a wide net for the purposes of its proposal right now. We'll see if they narrow it in the proposed rule itself. But again, I think they take a broad view unless there's a reason to kind of bring that back that they see in the comments even to the proposed rule. So just quickly before we turn it over to Tom, just a quick recap of the timeline, what we've seen historically, how the Bureau's moved through its mandate to conduct this study, and then moved into the proposal that we've seen in the SBREFA process. And then moving forward from there, we'll see the NPRM, the Notice of Proposed Rulemaking, expected sometime this spring. Obviously, expectations are a little bit loose, and there's not a whole lot of insight into when exactly we'll see the NPRM. The comment process is typically 30 to 90 days. It's difficult to tell with this particular proposal because the proposal itself is fairly simple and straightforward, but the underlying issues are very complicated, and so it could go either way on how much time the Bureau decides to provide for the public comment process. Then obviously the Bureau will collect and review those comments and finalize the proposed rule. And then the implementation of the rule is set by statute for 180 days after publication in the Federal Register of the final rule. So there's a little bit of lead time set by Section 1028 itself built in. And then just because we can't really talk about the proposal without going back to the arbitration study, which will definitely come up in the comment process. The final study was not subject to public comment yet, but it certainly will be during the notice and NPRM process. And so just looking at the scope of the study and what they looked at, clauses, incidents, consumer understanding and awareness, arbitration incidents and outcomes, class litigation incidents and outcomes, individual litigation incidents and outcomes, and then a variety of other areas that the Bureau looked at. And from there, the elements, sort of the underlying data that they analyzed, so consumer finance agreements, about 850 of those, consumer finance arbitration disputes, almost 2,000 of those, and almost 3,500 individual federal court lawsuits. So, not spending too much time on this, wanting to get into the meatier issues, but just realizing that the scope of the study and how industry is really going to need to dig back into the study and kind of draw some arguments out of that as they move into the comment process. So with that, and these slides available to you after the presentation, I'll turn it over to Tom.
Thanks, Peter, and good afternoon, folks. I just wanted to touch briefly on the underlying issues here, just to get a sense of what are the policy values that CFPB hopes to address with its rule, the public interest and the protection of consumers. And as an earlier slide pointed out, the Federal Arbitration Act was enacted back in the 20s, so it's been around for about 90 years. And it was enacted to overcome what had been judicial hostility to arbitration clauses and agreements. So it made arbitration agreements presumptively valid, whereas prior to that time they had been presumptively invalid at common law. And of course this is well before the Rule 23b3 spurious class action. That's their term, by the way, the committee kind of attached this derogatory term to the 23b3 class. That class was born in the 60s, 1966, but it really did not come of age until the 80s. And the 80s is when we saw this blossom of consumer class actions, and particularly in the financial services industry that I think most of our listeners are engaged in. But I just want to emphasize that it's not a procedural device, of course, that's been around forever protecting consumers. It's not a procedural device, really, that our nation's court have amassed a great deal of clinical experience with. And in fact, there's been a lot of abuse and acknowledged abuse of this device since it became so rampantly in wide use in the 80s. A lot of that just comes from the discretion that's vested in the trial court to certify a class under 23b3 where common issues are viewed as predominating over the issues that affect only individual class members. And this linchpin, and we see this coming up in the rule that the CFPB is proposing here, the linchpin is, especially where individual recoveries are so small that as a practical matter, consumers are not going to pursue individual recoveries because it's just not worth it to get a lawyer involved or even for their own time and expense. But yet in the aggregate, they are worth something. That's often been viewed as a reason to certify a class, and it's part of what's driving, as we're about to see, the concerns at CFPB now that Concepcion and those rules have been erected. You know, the industry response that came around from this expansion of consumer class actions took about 10 years to hit the streets, and that was arbitration provisions with class action or class arbitration waivers. So I think what we experienced in our client base back in the 90s was if you had an opportunity to impose a clause like this at that consumer interface, we advised that clients should do that. Not everybody has that opportunity, and folks, you know, selling products on the shelf and in other areas, you mentioned payment processors, and we don't think of them as being consumer-facing, but in the law that's developed since then, payment processors are often able to take advantage of the arbitration provisions of their clients. So wherever you have this agency relationship, a debt collector, for example, payment processors or otherwise, if they're acting in the scope of their agency, they can take advantage of the consumer agreement that is underlying their actions. The decisional law, as we went forward in the 90s and we were trying to enforce these arbitration provisions in mass consumer contracts, was all over the place. There were some states, and California, I guess, is the classic example, and that's what comes up in Concepcion, that viewed the mass consumer contract as a form contract of adhesion, and that the arbitration provision, it might be entitled to enforcement, but to the extent it waived any class treatment or class arbitration, that was often challenged as unconscionable, substantively unconscionable, and would get shot down. Many other states, though, you know, we had good success getting those enforced. So the law was a real patchwork of outcomes. Sometimes they give effect to the arbitration clause, but not the class arbitration waiver, and you got a lot of mixed results. Just briefly, this Discover Bank case in 2005 in California, this is the kind of rule of law that was before the Supreme Court in Concepcion in 2010. So 5 years before that, in 2005, Discover Bank had been sued in a class action. The class was challenging how late fees were computed. The cardholder agreement, which adopted Delaware law, included an arbitration clause that prohibited class-wide arbitration. When Discover Bank moved to compel, the trial court enforced the arbitration clause, but ruled in a classic way that we just discussed that the class arbitration waiver was unconscionable. The Ninth Circuit actually held that the FAA preempted that state law rule against arbitration waivers, kind of anticipating what the Supreme Court was about to do. But the California Supreme Court held that class action waivers are enforceable in consumer contracts of adhesion. They just declared, by and large, a rule, is how it got interpreted, that the FAA did not preempt the state court from doing that to protect its state consumers and their substantive rights to pursue class remedies under a variety of the California consumer protection statutes. So when that case came up, AT&T Mobility versus Concepcion, about 5 years later, worked its way up to the Supreme Court. The Discover Bank rule was what was at issue because the California state courts had ruled that those plaintiffs could not be compelled to arbitration and that they were entitled to class arbitration if they were. What the Supreme Court held was that the state courts could not articulate a rule that purports to disfavor arbitration in any way, nor could they kind of manufacture a class arbitration that's contrary to the fundamental attributes of arbitration, like bilateral arbitration, because, of course, what you have in that situation is an arbitrator purporting to exercise jurisdiction over absent class members. And when an Article III judge does that, she has, a great deal of jurisdictional jurisprudence in her favor, but an arbitrator is just, working as a contract between two parties, and there are a lot more due process concerns with class arbitration. But many of us, when this 2010 decision came down, we're interested to see how the law would develop, because right out of the gate, the decision seemed to emphasize a lot of the pro-consumer aspects of AT&T Wireless's arbitration clause. And I think this is going to come up with the CFPB rulemaking, because that arbitration clause guaranteed a minimum of $7,500 award and twice the attorney fees to any consumer who prevailed in arbitration and bested what AT&T's last offer had been, last settlement offer. So it was viewed as a guarantee to be made whole, and the Ninth Circuit even had noted, I think, that, or the district court, that consumers were better off in arbitration under this sort of agreement than they were as absent class members, which, as we all know, those are the ones who often get thrown under the bus in a class settlement, and their recoveries are quite small. But this debate didn't last very long. So whether Concepcion involved a finding that AT&T's arbitration agreement was not procedurally or substantively unconscionable, or whether it invited future litigation on that basis, some state courts took up that question. I know Massachusetts and Missouri were a couple of those who felt that a challenge to an arbitration provision could still be had if procedural or substantive unconscionability was pled, and it was a plausible allegation. But as we're about to see in some of these subsequent decisions, the FAA, the Federal Arbitration Act, continued to prevail, and what Concepcion was really doing, and the way it's been read, is a categorical rejection of arbitration provisions in mass consumer contracts. Those are preempted by the Federal Arbitration Act, and the ability to plead a case that a particular arbitration provision is unconscionable seems to have gone out the window. So a couple of cases, and Allison mentioned a third that came here just at the end of the year, this DirecTV case. But all three of these cases stand for the proposition that this test of the limits of Concepcion had come back with the same result. In CompuCredit and in American Express, these were class action plaintiffs claiming that their federal claims preempted the credit card agreement's attempt to impose arbitration, either because, for example, under the Credit Repair Organization Act, that statute included language to the effect that private parties had a right to sue, quote unquote, and it mandated a disclosure advising consumers that they had this right to sue. And I think what the plaintiffs were trying to do there was enlarge that into, well, that must have a preemptive power over the FAA. That's a statement in the Credit Repair Organization Act that the Federal Arbitration Act's policy in favor of arbitration has to stand down. And then somewhat similarly, in this Italian Colors case, that was an antitrust claim, a Section 1 antitrust claim, and their argument was, look, no one is going to pursue an individual antitrust claim in arbitration. It's impossible, given the expense of putting a Section 1 case together. But in both cases, and I think there's another slide on this, Peter, the court held that the CROA did not create a federal claim, a guarantee to go into court, and it was silent on the arbitrability of the rights that it created. So what the court did not see in the CROA was a contrary congressional command that overrides the FAA. And one question I know that John Cooney is going to address is, of course, Dodd-Frank seems to indeed contain a contrary congressional command for the CFPB to make a rule like this. The Italian Colors case kind of goes to that substantive unconscionability issue. It's like, look, nobody can bring an antitrust claim on an individual basis in arbitration. So if there's not a procedural pathway for me to arbitrate this, then the whole policy of the antitrust laws is going to go down the drain if you make me arbitrate. But that was also a failing argument, and the court pointed out that, look, you get treble damages as an antitrust plaintiff. Congress has taken a number of steps to encourage the bringing of those claims. But again, there's no intent, and we see no language in the antitrust laws that add up to a contrary congressional command.
So Tom, one of the themes that I think emerges from this line of cases, and I think this is important because it informs what the CFPB is intending to do or potentially intending to do, is the concept of preemption and then the concept of the effective vindication doctrine, the idea that you can't have a law out there that can't functionally enable a plaintiff to exercise the rights the rights contemplated by that law or by that statute. And so it kind of goes to the practical versus the theoretical. And then, of course, the concept of preemption. You can't have a state law that's seen as undermining the purpose of the Federal Arbitration Act in this case. And I'm wondering if you can talk some more about those two ideas which seem to animate this whole line of cases.
Well, you cannot have a state law that discourages arbitration agreements in any particular way that, it's the anti-discrimination clause that somehow treats arbitration agreements different than any other contract. And that's what was happening in the Discover Bank case. And it's been tested whether Concepcion is really applicable, like in state court. If I'm in a state Supreme Court, can somebody raise this preemption? And the answer is a resounding yes, it does apply in state courts. And that's a point that was driven home in this recent Imbrugia DirecTV case in December. The second question you raised, though, about the practical effects of arbitration and whether that stands as an impediment to pursuing an action. The cases so far, Justice Scalia and then the majorities that have joined him, they don't have a great concern about that. And I don't think it has not been a winning argument, particularly in this American Express case. So it looks like when the CFPB takes this on, it'll be interesting to see whether they're trying to get the financial services consumers back into a position they were in pre-Concepcion, where these arbitration provisions can exist. And, it's interesting, a point Peter made, that one of their proposals is, it's effective. It seems to be effective under one of these proposals. An arbitration clause is effective until a class is asserted. Then it's not. But, of course, there will probably be a history of arbitrations with individuals, which often comes into play in Rule 23b3 superiority, whether individuals have been pursuing individual remedies for a given course of conduct. And then after a class, if it fails to get certified under a lot of the stringent new class certification standards, it looks like that arbitration provision would come back into play and it would control thereafter, which has the effect of, I think, locking in that class certification decision, giving it some issue preclusive effect going forward.
Interesting. Yeah, it just seems when you look at the CFPB proposal, and even if you go back and you look at or read about the way that Section 1028, which is the provision in the Dodd-Frank Act that enables the CFPB to do an arbitration study and then gives them the opportunity, but not necessarily mandates that they do or consider writing a rule, the effective vindication doctrine, the idea that you can't have a statute out there that doesn't practically enable an individual consumer to exercise the rights contemplated by that statute. And that was very much the Italian Colors case, and I would not be surprised to see that be some part of the underlying subtext of what the Bureau ultimately puts out there in its rulemaking. Just knowing a little bit about the way the agency thinks and about how Section 1028 kind of came into existence. And I think your point about issue preclusion in the new regime where you kind of get one opportunity to seek class cert. If you don't get that opportunity, it goes to arbitration, and it seems that the rule almost contemplates that. The proposal,
it does, and I know we're going to talk in a little bit toward the end about what the future might look like, but, for purposes of CFPB and its rulemaking now, they should be encouraged to take a real serious look at how absent class members have fared over the past 20 or 30 years. So the answer is not that great, right? And the point that's been made in Concepcion and some of these other cases is that under the right arbitration clause, like the AT&T mobility clause, these individual consumers are often better off. They're given an incentive to bring individual claims to arbitration, and they come out better than they did as absent class members, getting the coupon or the check for, $2 or $3. And the breakage on these class action settlements, which we all know is extreme.
John Cooney is going to discuss to what extent a proposed rulemaking would be susceptible to some kind of court challenge and how all of this fits together with existing doctrine and what Section 1028 does and how that marries up or doesn't marry up to what the Supreme Court has recently held in these cases that Tom just discussed.
Thank you, Allison. My colleagues have given me the impossible job of discussing possible legal challenges to a rule that hasn't been issued yet. In general, it's very difficult to predict in advance what objections might be raised to challenge a rule. Most challenges are tied to the factual findings articulated by the agency in the preamble to the final rule and how the agency decides to frame and resolve the problems it identifies. The agency has great discretion as to how it frames the facts, the problems, and the solutions. And so regulated entities really cannot identify in advance what challenges might be available and which ones would have the greatest probability of success. They can only do that when they review the final rule, and it's always a surprise, no matter how intimately involved you've been in discussions with the agencies before the fact, to see what issues are actually presented in the rule. Because the process is very dynamic, the agency actually listens to the regulated entities. It listens for several purposes, but mostly it's trying to understand what issues are important to the regulated entities and to try to cast its findings and solutions in a manner that produces the least litigation risk. And in the ideal world, the agency also figures out a way to divide the potential coalition against it and recruit some supporters from among the regulated entities who decide they have more to lose if a challenge to the rule is successful, as opposed to what they manage to obtain through persuasion of the agency in the rulemaking process itself. So it's hard to overestimate the importance of engaging with the agency either directly or through a trade association and working hard on your issues. That's when the agency has the most discretion and the greatest degree of flexibility, and that's where most of the great regulatory victories are obtained. But let's assume that that there is going to be a rule and that most of it is unknowable at the present time. But you can look at the plain language of the statute and try to anticipate some of the challenges that might be raised. And I think that there are three possible challenges that can be identified in the face of the statute, so I thought that I'd run you through those quickly. First, under Section 1028A, the agency is required to conduct a study of arbitration before it can issue a rule prohibiting or imposing conditions on the use of arbitration agreements in connection with the jurisdictional term, the offering or providing of consumer financial products or services. There may be a challenge to the final rule when you see the products and services to which the rule applies, and people may decide that some of those are not actually consumer financial products or services. So you can put a bookmark on that one. Everyone's going to look at that and see if products that they're offering are affected by the rule. So you can identify that, watch this space for further developments, but you can't say more about whether there will be a challenge on that front. What you can see is that the findings in the rule must be, quote, consistent with the study, close quote. Well, this requirement offers little room for a successful procedural challenge to the rule because the agency is very clever and has a lot of smart people who will know how to tailor the framing of the issues and the framing of the solutions in a way that they relate directly to the facts that are found. So while that's a theoretical possibility, it's not one that's likely to pan out when it comes time to figure out if there are challenges that can be raised with some measure of success. The second one is Congress's delegation of authority to the agency. Section 1028B authorizes the agency to prohibit or impose limits on the use of arbitration agreements for consumer financial products if it finds that such a prohibition or limitation on use of an arbitration agreement, quote, is in the public interest and for the protection of consumers, close quote. The magic language there is the public interest term. The public interest standard is extremely broad, essentially has no limits on it, and has been upheld by the Supreme Court in a long series of cases starting in the 1940s. To tell the agency to act in the public interest, it turns out, is a constitutional form of delegation of Congress's authority to an agency. So while this is very broad, it doesn't offer any realistic possibility of success in challenging the rule. So that brings us to the third argument that's available here. And this is the one that we've heard talked about most by people in the industry as the agency has been going forward with its study and as it's contemplating the notice of proposed rulemaking. It's clear that but for the presence of the Federal Arbitration Act, the agency undoubtedly could adopt a rule, assuming it has proper language from Congress, that prohibits or limits use of arbitration agreements if the facts would support such a conclusion. And federal courts give substantial deference to agency findings of fact. So if the FAA did not exist, it's highly likely that Congress's delegation of authority would be held to permit the agency to prohibit the use of arbitrations in certain circumstances. But the FAA does exist, and suggestions have been made that Section 1028B could be challenged successfully on the ground that Congress has made an unconstitutional delegation of its authority to the agency by granting it authority to partially repeal the Federal Arbitration Act. The challengers would argue that only Congress may repeal a statute, and that what the agency would do here is that the agency essentially would be given the tool that would constitute a partial repeal of the FAA. This argument, however, depends upon a characterization of the effects of Section 1028B, that its effect, as applied, would be to limit the types of arbitration to which the FAA applies. The standard that otherwise would apply has been limited, and the effect is to narrow the effective scope of the FAA. I think the Justice Department and the CFPB would present the case in a way that the challengers would be forced to admit that Congress could accomplish this result, because a later Congress can always change the law adopted by a prior Congress. And if the Congress that adopted Dodd-Frank wanted to change the results, it could do that. Their objection essentially would boil down to the technique that Congress used to accomplish this goal. The CFPB, on the other hand, would defend on the ground that the delegation in Section 1028B is lawful. It would point out that the text of the FAA has not been changed in any respect. What we're really talking about here are practical effects. And the agencies would point out that there are no magic words that the court requires Congress to use in order to limit the effects of an existing statute. A preliminary phrase such as notwithstanding any other provision of law obviously would give the agency the running room it needs to override the effects of a prior law. But Congress has not required that be used. The committees use all kinds of different languages to articulate the same result, and the courts have never seized upon magic language. What the courts essentially require is that the language, the phrasing be clearly identifiable as showing that Congress intended to give the agency the ability to restrict something that was being done under another law. And the CFPB would defend on the highly technical ground that in many prior cases, the courts have upheld statutes that authorize adoption of rules that have the effect of limiting the scope and effect of other statutes in a manner that is not accomplished by an actual change in the language of the prior statute. And so that will be the ground that the agency defends on here in my best estimation. And so it's possible to articulate the arguments pro and con now, but until we see the case law that the parties come up with, we'll just have to be assuming that that's the broad thrust. But I think that will be somewhere near the center line of the challenge and the center line of the defense. Maybe it may differ 5 degrees, 10 degrees from that, but that should be the thrust of the legal debate about the one issue that I've heard so far that's identified as a potential legal challenge. Everything else is going to turn on the facts that the agency articulates, the problems it identifies, and the solution it chooses to adopt for those. which brings us back to the rulemaking process itself, where the rubber meets the road in all of these big agency rules.
Thank you. I'd like to remind everyone on the phone that you should please feel free to ask us questions, and as we receive them, we'll answer them. John's discussion about the potential basis for a legal challenge, of course, keeping in mind that we don't yet have the rule in front of us, brings me to a couple of points that I think are particularly noteworthy. One, this goes to the timing and the practical effect or implementation of any rule, and Peter perhaps can talk to us a little bit more about what's contemplated in terms of time. Obviously we don't have the proposed rule in front of us yet, but in the name of trying to manage, new consumer-facing agreements as well as contemplate risk in the future, it's obviously helpful to have in mind some timeline, and then of course, in anticipation that even if the rule was to have an effective date, it likely would be held up to some extent in court, because I think it's all but inevitable that there will be at least one legal challenge of the kind that John laid out and possibly others. So Peter, what's your sense of the timing based on your review of the rule so far and the comments that the CFPB has put out in the public?
Sure. So, as we see in the slide here, there's a couple steps before we get to actually having to toss your arbitration clause out the window. Obviously, we're awaiting, as John had said, the NPRM to really see what the Bureau will propose. We have a gist of it from their SBRIFA framework, but we'll need to see that. And then, as the second bullet indicates, once public comments are in and the agency is digesting them, finalizing the rule really is with the agency, and so it's a little bit difficult to predict when they will issue a final rule. In terms of timing, what we've seen in the regulatory agenda, we are expecting an NPRM sometime this spring, beginning of second quarter, perhaps sometime within the second quarter of this year, possibly, as the agency further digests the information and discussion it's received so far in its proposal. Like I just said, that the final rule will really depend on the agency, and then compliance, again, is governed in part by the Dodd-Frank 1028 itself, which gives us 180 days after the effective date of the regulation. So about roughly 210 days from the final rule will actually have compliance obligations. So it's down the road, and as you said, Allison, any legal challenge could potentially tie this up even further. So it's certainly not something that we're going to be seeing compliance issues on the ground with anytime soon. But the process, the rulemaking process, is rolling on, and that will bring us to our next slide, where we'll kind of get into some of these compliance and class action issues.
So Peter, you mentioned a few things, and I'm hoping that you and John can maybe put some more meat on those bones. SBRIFA is the small business review that the CFPB and other agencies are required to do. And John, based on your extensive experience with rulemaking, maybe you can give us a little bit more of an understanding about what that even means, because that announcement provided some of the intelligence or line of sight into what the Bureau is considering here.
Right. The Small Business Review Act is intended to address one of the undeniable facts about rulemaking and government regulation generally, which is that there are large economies of scale in responding to government rules. And that's been a constant comment of the small business community, that they disproportionately bear the expenses. They have a smaller base, a smaller end, and so they have to spread the fixed costs of responding to government regulatory programs over a much smaller client base. So it ends up putting them at a competitive disadvantage compared to the large competitors who have a much larger client base over which they can spread that. Especially the Gingrich Congress in the 90s emphasized this point, and Congress has tried to work out a way over time by which the small businesses can be assured that their concerns will be heard. And they're not just on the overall challenges, the same thing that the trade associations that represent the largest competitors in a field would raise, but to say this is how that provision, if phrased the way you intend to do it, will particularly impose costs on small businesses, and there are other ways that you could do this that wouldn't have the inadvertent effect of penalizing us and shifting disproportionate costs onto us. And so the agencies listen carefully to that, in part because it's a statute, but in part because they understand that they don't have a small business framework, that they are much more familiar with what the large entities who lobby more effectively think about something, and so that they're very interested in that because they don't want to create impose burdens on what is a very attractive group of people and one that enjoys a lot of congressional support.
And, in terms of final rulemaking, a lot of people listening in on this call have probably at some point participated in the comment process, but there may be others who have not. And I know that, John, you've been involved in that. Tom, you've been involved in that. Peter, you've been involved in that. I've been involved in that. Perhaps some of us can discuss in a little more detail what it means. So the way, and the reason I'm doing all of this is I want everyone on the phone to understand that there are real timelines in place here. And, the CFPB's announcement of a notice of proposed rulemaking has a number of things and steps that follow from that and flow from that, including the small business SABRIFA panel briefing that was just described. But also, the agency will propose a proposed rule that will be open for comments, and, of course, the final rule. So, Peter, you've worked on this, on these different issues in the consumer finance space now for a number of years. So maybe you can give us a flavor for what that means in terms of timing, just briefly, and then we'll talk next about some of the risks associated with managing in anticipation of this coming down the pike.
Absolutely. Like you said, the NPRM will be open for public comment where industry and really anyone can submit comment letters to the Bureau for its digestion and consideration as it looks to finalize its rule. The comment process is typically 30 to 90 days. Again, with this rule in particular, it's a little bit difficult to gauge how much time the Bureau is going to give industry and the public to comment, given that what we've seen so far, the proposals are fairly straightforward, but the effects and the underlying issues are fairly complicated. So, I think anywhere between 60 and 90 days is probably a good estimate in terms of what we're looking at for timing for getting comments in, and then it's really with the Bureau to digest those and to work on its final rule. John, if you have any more insight into the timing of that, it really depends on what issues are raised, what sort of messages the Bureau is getting, and how it feels it needs to shape its final rule to be a good rule for industry, be a good rule for the agency, and also protect it from as we've discussed, some of the expected legal challenges.
You raise a good point based on the political cycle. We are coming to a time when there will be a lot of concentration in Washington on what are known as midnight rules, which are the rules that are issued in the last stages of an administration that they try to get out the door and into the Federal Register by January 20th, so that they go into effect, and it becomes much harder for their successors to make changes in those rules or to roll them back. And then they count on having a blocking minority in at least one of the houses of Congress that can prevent a statute from being passed that would undo it. And so that they essentially try to get the existence of the rules sunk in concrete before there is a change in administration. And the CFPB is a little bit different that way because it's more independent of the political process than all the other agencies. But they will be subject to the same gravitational effect of understanding that there's going to be a change in administration. It's probably likely that the Republicans will still have at least one House of Congress, perhaps two, and there could be a change in the party that has the president. So your main goal would be to try to get the rule in place, out the door by January 20th, so that it's in place to greet the new administration when it comes in, and you hope that way it can be taken as a fait accompli. And if there is going to be any change on it, the agency and its supporters will have the whip hand in minimizing the number of changes that will be made or preventing them altogether.
And we might see some support, for that idea in the dual nature of the proposal we've seen. One is getting rid of the class action waiver, which the Bureau has expressed as kind of one of its main goals as we look at arbitration agreements in general. But then also as a second part, a information gathering rule or regulation that would obtain more information on individual arbitration agreements themselves and allow the Bureau down the line possibly to have a resource to look at if it is going to engage in further rulemaking, determining what arbitration agreements might be more consumer friendly than others, and if it wants to set regulations on individual arbitration agreements in addition to what it's proposed so far.
So, there's a lot of obviously next steps and things to think about. The scope of the Bureau's proposal, and one of the issues that John touched on, that I think Peter's touched on, that Tom touched on, and that I touched on as well at the beginning, is what's the scope of the CFPB's jurisdiction as to financial services products? When are you within or without the agency's jurisdiction? And this is an issue that has been percolating, as I said earlier, for a number of, a couple of years now. It's mostly manifested itself in certain kind of enforcement actions, but I think obviously if this rule gets enacted and it isn't clear which products or services are within or without the scope of the rule, there's going to be some amount of, collective anxiety / possibly, challenges to the rule. And the question is, are you offering or providing a consumer financial product or service? Obviously, if you're a bank and you're offering checking accounts to consumers, I think we can all agree that that's within the scope of the Consumer Financial Protection Act jurisdiction. But what if you're doing something that's a little bit less clear? I think that is exactly some of the issue here that is really going to be forced to the surface with this rule, because this rule has the potential to significantly impact every single provider of consumer financial services or products which the CFPB considers to be a provider of a consumer financial product or service. And the other thing I note is that in the economy as it is right now, with emerging payments and new products coming to market all the time, companies that had historically not been called so-called financial services companies or providers of consumer financial products or services may now be in that category. And what does this do to them? What does this do to their management of how they think about writing these rules, managing risk? Do they shift the risk to consumers? Does the cost of a product or service go up? How does this impact innovation? Does this stymie innovation if you're a small payments company and you're considering taking to market a new product? Are you thinking about the ramifications of a provision that doesn't allow you to be insulated from, class actions? Maybe you are, maybe you're not. It would depend on a lot of factors. But I think these are the kinds of things that we're going to see really animate the discussion in the coming months once the notice of proposed rulemaking hits, and then, of course, after that. And I don't know, Tom, you've spent a lot of time thinking about and talking about class actions and how companies can respond best to them. What are your thoughts on what this could do in kind of an amorphous way to companies that may or may not have historically thought of themselves as being within the scope of the Bureau?
Well, and so it'll be interesting to see if whatever rule comes out the other end of the process that you all have been describing applies to, a financial services product or service like a wireless contract or anything that has the component of some sort of financing to it, or really it's just a defined constituency. And, there's some suggestion in the proposals or the outline of the proposals that have been aired that there's going to be some sort of safe harbor or best practices arbitration provision that might be adopted. Is that going to be something that's like Concepcion? Because that AT&T mobility arbitration clause was dealt with in great detail by the Supreme Court, and they seem to be ruling that arbitration clause is not procedurally or substantively unconscionable as a rule of law. So is that going to become a touchstone? And what's this rule going to look like? If I have an arbitration clause that meets that kind of test, am I going to be good to go? What I will be very surprised indeed to see, no matter what the rule is that comes out of this process, is that class arbitration becomes the next hot thing, because I can think of nothing that would be more miserable and counterproductive for industry than class arbitration. Because, I mean, look at all of the other reforms that have happened in class action practice of the past 10 years. It's all aimed at improving our ability to appeal, right? We now get enhanced interlocutory appeal of class certification decisions under Rule 23F, and courts of appeal are encouraged to take those up on an interlocutory basis. But in arbitration, I get no appeal rights at all. And I think that, you know, as the Supreme Court cases said, arbitration is not a device that's well suited to handling class claims because it's just too informal. And, you know, I think as a defendant, we always benefit from a lot more precision in the class certification process, not less. So I'll be surprised if class arbitration becomes a cottage industry. And it'll be interesting to see how choice of law provisions, you know, play out. And there was some of that in this recent DirecTV case, because it seemed to be, that arbitration clause seemed to be saying, you know, here's our arbitration provision and class arbitration waiver, and if the law in your state would render that unenforceable, then we're dropping the entire arbitration clause, right? Because we're not going to class arbitration. That was an arbitration provision that predated Concepcion, and there was what I view as a needless debate, and I think that's where the Supreme Court came down. It was a needless debate about whether that choice of law, that pre-Concepcion law in California, Discover Bank, somehow survived Concepcion, and of course it did not. But it'll be interesting to see if choice of law issues come back to the fore with the CFPB's rule.
You know, we talked very early about this when you were speaking before about kind of two of the themes that emerged from the Concepcion line of cases, and one of them has to do with preemption. And I note that this issue of preemption, which is one of the bases that John also articulated as a potential basis for a challenge, the theme of preemption is actually throughout the Dodd-Frank Act, and specifically in the Consumer Financial Protection Act. It's something that obviously was of top of mind to Congress when the CFP Act was being drafted. And I think that this is obviously going to be in the subtext of any rule that comes down as well, which is federal law that's seen as being less protective of consumers than state law should step aside and let state law trump. And that's been a theme in the Consumer Financial Protection Act. You know, that's obviously counter to the analyses that came out of Concepcion and DirecTV, but I think that that's obviously top of mind as well for some of the folks over at the Bureau who are looking at this rule and trying to figure out how they walk the line between federal preemption doctrine as expressed in Concepcion and the concerns about protecting consumers, and can they make a federal law that's maybe more protective of consumer rights so that they don't have to deal with the question of preemption. And all of these issues are really ripe for challenge of some kind, I suspect, in court in the near future when this rule is finalized. And with that, I'll let every of our participants have a few final comments about observations of the rule, and if anyone else has any questions, we can answer those as well. So Tom, if you want to start.
Sure, and well, just on that point you raised, you know, the preemption issue is one about conflicting state law. And you know, my own view of it is that the FAA, you know, there's room for conflicting federal law. And John, you know, you would correct me on my Latin, so I'll try not to, what's that statutory construction phrase, that the specific controls over the general, right? So I think that in any other federal regulatory regime, you know, there's probably, the field is open for Congress to pass laws that are restricting this, you know, general FAA, you know, right to arbitration, and that it be judicially favored, except in these circumstances. Now, the issue is, and I'll pass it to you, whether they can just pass that to an agency and say, you go do a study and decide if that's true.
As I say, the challenge will depend upon a characterization, on an effect. This has the effect of restricting the scope of arbitration clauses. This has the effect of changing the preemption doctrine, but it doesn't modify the statute itself. The statute remains the statute. The FAA will not be changed. It's just the places where it can be applied will be restricted by a subsequent act of Congress. And the question will be, I think, was it clear that Congress understood that what it was doing might have the effect of limiting the scope of prior Supreme Court decisions? Congress is allowed in a statutory context, not in a constitutional context, but in a statutory context, to modify the governing law in a way that has the effect of reducing the importance of a Supreme Court decision. And the Supreme Court handles cases like that all the time. In fact, sometimes it invites Congress to change its own law. And so it's hard to draw a line here and say it is or is not going to be that way. It'll all depend upon how the courts decide whether Congress's intent was sufficiently explicit that they're comfortable saying we're prepared to accept something that has the effect of limiting the scope of the FAA.
Thank you. And Peter, do you want to just say a few final words about?
I would just say, look for and expect the specific language of the requirement that class action waivers be banned, and analysis of how that's actually going to play into an arbitration agreement that you might have, along with the class action that might be going on. And the Bureau's promised model language indicated, not promised, but indicated that there might be model language. So how that model language syncs up with the actual requirement, and how both sync up with the overall sphere of the arbitration agreement, plus the class action that might be going on outside of that.
Thank you very much for joining us today. We greatly appreciate it. This is Venable, and we've enjoyed your presence at our webinar on arbitration. Later this week, we will also be sending out to all participants a copy of the PowerPoint presentation that we used. And of course, if you have any further questions about today's presentation, you can email any of us, and we look forward to that. Thank you so much for joining us.